Ladies and gentlemen, Steve Casaus is not guilty. There is no question that what we have been dealing with, what we've been hearing about this past week and a half, is a horrendous tragedy. That's not what you have to decide. You don't need to decide if this was a horrendous tragedy. What you need to decide is whether Steve Casaus is guilty. Now, as Mr. Clark mentioned on opening statement, with a case like this, a wide net was cast out. And in that wide net, an innocent man, Mr. Steve Casaus, was ensnared. Convicting an innocent man will not bring justice to Omaree. Convicting an innocent man will not make this okay. What it will do is continue the injustice of what went on here. Now, as I put on this chart here, remember what we talked about when we were doing jury selection, the presumption of innocence. Those aren't just words. That is where you start in this case. Presumption of innocence. Mr. Casaus is innocent until the state has proven beyond a reasonable doubt that he's guilty of these crimes. You don't have to prove one darn thing. We don't have to put on Dr. Penland, which I'll talk about in a minute. We don't have to cross-examine any of the state's witnesses, or as they called it, put out red herrings. We don't have to do anything, because the state has to do it. And until, or unless they have proven it beyond a reasonable doubt, you must acquit Steve Casaus. Now, I am not going to go through the jury instructions with you. You can read them back there. But I want you to think about the words a little bit as you're reading them. It's not right to reasonable doubt. It's not right up to it. It's not somewhere before reasonable doubt. It's beyond reasonable doubt. That's what the state has to prove to you, beyond that point. So don't just gloss over those words when you go look at those jury instructions. Now, the state said that defense is going to point the finger at Cynthia. Defense isn't pointing the finger at anybody. We don't have to prove anything. You know who pointed the finger at Cynthia Varela for doing this? Cynthia Varela pointed the finger at herself. And Nevi, that little girl, pointed the finger at her own mother. We're not pointing the finger. You, ladies and gentlemen, had to sit through a horrific trial. And quite possibly, you saw and heard things during this trial that will stick with you for a long time, if not maybe, unfortunately, the rest of your lives. And now, the hard part starts, believe it or not. The hard part is when you have to go back into that room there, and you have to take out that sympathy, that emotion that all of us experience. You've got to take it out and leave it at the door. And when you go in that room, the only thing that should be going through your mind are the facts, the cold, hard facts, the evidence, the proof that the state brought you. And once you've done that, it'll be clear that the state has not met their burden of proof beyond a reasonable doubt. So I'm going to talk about some of the evidence, not all of it. You've heard it through the state's closing argument. You've been sitting here paying attention with every witness, taking notes. I'm going to talk about some highlights. Now, Cynthia Varela, she's the one who killed Omaree. You heard that she confessed to police. Now, this was before she knew that Omaree was dead. She just thought Omaree was injured, just like Steve. Because at no point during the interview did the police officers tell Cynthia or Steve that Omaree was dead. Okay? So Cynthia confessed to police that she did it. It took a little while, but she got there. And she said she kicked him, she disciplined him, she did it. You did not hear that Steve had any role in that whatsoever. Actually, it was quite the opposite. What you heard was that Cynthia said, Steve kept saying, call 911. Call an ambulance. Call 911. Why would she say that if that's not exactly what happened? Now keep in mind that, again, both Cynthia and Steve believed that Omaree was still alive when they were talking to police officers. And if you remember, with Detective Quillman, he spent a good deal of time talking to Steve about these safe house interviews that they do with children, and that the children were being safe housed at that moment. And Detective Quillman said to Mr. Casaus, what are the kids going to say happened? Steve said, I guess they're going to say Cynthia did it because she did. If he thinks Omaree's alive, why would he lie at that moment? The other kids were there, and they were being interviewed. Cynthia was told the same information, and she said she did it. Now, the state has talked about these. Before I get there, you also saw the news footage where Cynthia said, I don't know, I kicked him the wrong way. Did she say Steve's name? No, she did not. She didn't say we kicked him the wrong way. We lost our temper. She said I did it. We're not pointing the finger at her. We don't have to. So the state made a big deal about these letters that you only heard a little bit of. You didn't get the whole picture there. You got a couple of statements she said in letters to her sister, who's the caretaker, foster parent for her children. You heard that Cynthia wrote these letters while she was in jail, now facing charges for murdering her son. So she's in a different place when she's writing those letters, isn't she? Not only that, but in the same letters, she's writing to her sister, forgive me, I want to have contact with my children, and oh please, can you send me some money so I can buy some stuff here at the jail? If those letters are certainly not even close to proof beyond a reasonable doubt that Cynthia didn't do this by herself. And remember that in one of the letters, Cynthia stated that she talked to her lawyers and she's recanting her confession. Don't forget that. Now, let's talk about Nevi. The state is relying on the statements of this little girl who's been through a whole lot. And Nevi really didn't say what the state expected her to say, did she? We did hear through her testimony that she has talked about this traumatic event over and over and over again to therapists, to her aunt, to the interviewer, several times after this happened, to me, to the district attorney, and then she had to testify. And you're going to get a transcript of Nevi's statement when you go back there to deliberate and read it. It's quite telling. But I'm going to go through a couple portions of it right now. Question. You told Danielle at the safe house that you told Mama to stop spanking Omaree. Do you remember that? Answer. Yes. Question. And you told your Mama to stop being mean to Omaree, right? Answer. Yes. Question. And you yelled at your mama to stop being mean at Omaree, right? Answer. Yes. Question. And that Omaree was in his bedroom when your mama pushed him and kicked him. Do you remember saying that? Yes. Question. And do you remember saying that your daddy told your mom not to do that to Omaree? Do you remember saying that? Answer. Yes. Question. And you told me that you remember the day that Omaree got hurt? That your mama was hurting him by punching him and kicking him? Answer, yes. Question, and I asked you, Nevi, if you remembered anything else that happened that day with Omaree? And you said no. Do you remember that? Answer, yes. Question, and you said you didn't remember anything else that happened that day. Do you remember telling me that? Answer, yes. Question, and do you remember telling me that the day that Omaree got hurt, that he was bleeding because of what your mommy did? Do you remember that? Answer, yes. Question, okay, now do you remember your auntie telling you that your daddy would be in jail for a long time for what he did to Omaree? Answer, yes. Question, okay, and Nika, your therapist, she also told you that your daddy would be in jail for a long time for what he did to Omaree, didn't she? Answer, yes. Nevi points the finger at Cynthia. The state has their killer. The state has the person who did this, but they want more. Now, you saw the drawings that Nevi did. I'm going to talk about them real quick, and they'll go back there and you can look at them as you deliberate. So I'm going to show you 3 drawings that were done about a year ago, approximately a year ago. Okay? That's Defendant's Exhibit D, and it shows mom punching Nevi, Omaree crying, I am mad, mom is so mean, I'm sad. Then we have Defendant's Exhibit F. Down here at the bottom is the drawing, and it says Nevi, mom, and over here we have Omaree on the floor crying because mom punched him too. If you remember, Sylvia said that she forgot to write hard after the word too. Defendant's Exhibit E. I'm mad at what you did. And the only adult figure in that picture is mom. And there's Nevi with the word punch by mom's fist, mom, other fist punch, and over here we have Omaree. That's Defendant's Exhibit E. Now the state showed the picture that was drawn more recently. And that picture is different. Absolutely, that picture is different because now we have Dad in that picture as well, don't we? Well, what preceded that picture? A play date at the DA's office. That's what preceded it. Nevi went to meet with the DA on Wednesday, the week before trial started, and all of a sudden, we have this new picture drawn. For the first time in almost 20 months, and Dad's in the picture. Well, apply your common sense to that, ladies and gentlemen. I'm referring back to Nevi's transcript again. Again, you can look at it when you go back there, just highlighting a couple things here. Question. All right. And when you went and talked to Nick and Maria, you talked about this case, didn't you? Answer, yes. Question. It's okay. And when you talked to Nick, you talked about what you were going to say in court today, didn't you? Answer, yes. Question. And you talked about what you had to answer the questions, right? She nodded her head. I asked, right? She said, yes. Question. And what your answer should be? Answer, yes. Is that picture that was drawn Wednesday before trial proof beyond a reasonable doubt? Far from it. Now, to put this all into context, what we've been hearing, the defense called Dr. Penland. Again, we didn't have to call anybody. But Dr. Penland was called to, and don't forget, you'll have her CV to look at, but look closely at her qualifications. And as she testified to, she was a director at YDDC for a number of years. Highly qualified, highly experienced psychologist, especially with children. And defense decided to call her to provide this context to memories. Now, did Dr. Penland tell you anything that you don't already know just by being a person? That sometimes your memories aren't accurate, and that sometimes your memory can be affected by things that people either tell you or experiences you've had or experiences you have in the future that affect these past memories? Of course, you didn't need Dr. Penland to tell you that. You knew that. What Dr. Penland did was give you this case study about this 14-year-old lost in the mall. And it's not hard to believe that that's true. And in fact, Dr. Penland said that she conceded, okay, maybe, Dr. Loftus, though the expert in memory, especially childhood memory, may have gotten in trouble ethically, that wasn't necessarily unusual in the field of psychology, that someone was always trying to find something wrong. But did that ethical issue change the results of Dr. Loftus, or the results of this lost in the mall scenario? It didn't. In fact, Dr. Penland said that study had been duplicated and replicated numerous times over the past 25 years since it was first done. And what Dr. Penland told you was that there's a difference between the truth, what actually happened, and a child's truth, what a child thinks happened, was exactly what we're talking about here. The truth and Nevi's truth. But let's recall just a couple of portions of Sylvia's testimony. She told you that Sylvia, told Nevi that Dad, Mr. Casaus there, hurt Omaree. Telling a little 5- and 6-year-old that, this trusted adult, her foster mother, her auntie, your dad hurt Omaree. Therapist told Nevi the exact same thing. Another trusted adult in Nevi's life. Your dad hurt Omaree. So taking that all as a whole, looking at these drawings that were done, all up until the Wednesday before trial, the child's memory was corrupted. It was tainted. There's Nevi's truth, and then there's the actual truth, and they're different. You heard that there were these several different safe house interviews that were conducted or taken of Nevi. And you heard sort of how they work. So for people who don't do this type of work, it was explained to the jury, you guys, that the child is brought into the room and made to feel comfortable. There's Play-Doh, there's age-appropriate things for a child to do. And then there's one other sort of non-intimidating, usually female figure in there, adult, to talk to the child. And the purpose of that is to make the child comfortable and to get to the truth, to get to the bottom of it, to find out what happened. And that's what they did here. And they did it right after Omaree was killed with Nevi. And Nevi said in that first interview, Mom did it. She did not say Dad did it. It wasn't until the passage of time, the aunt telling Nevi Dad did it, the therapist telling Nevi Dad did it, not until about 18 months later when she's re-interviewed in the exact same setting at the safe house, that Nevi changes her story. Of course she does. That doesn't make it true. That just means her memory's been altered. Now the state would have you believe that Nevi finally felt safe to tell the truth. That doesn't make sense. It doesn't make sense, but even if you think that somehow there's some truth in that, where is the proof that Nevi finally got to a point that she felt safe to say this? Where is the proof that the state brought you to make that conclusion? Did they bring any therapists to tell you that? No. They didn't bring one person that got on the stand and said, let me tell you, ladies and gentlemen of the jury, why Nevi didn't say this earlier. She didn't say it earlier because she was afraid of Dad, and now she feels safe. And the state is wanting you to believe that. They're wanting you to conclude that with no proof. You can't do it. They needed to bring you something, and they didn't. Also, let's look at Nevi's behavior. The state played the lapel for you again. You got to see Nevi on the camera when she heard that her dad was here watching. Let's start with the lapel. In the lapel, Nevi seems a little bit nervous. There's all these strange people in her house. And she's standing there right next to her dad. She seems fine. She doesn't seem afraid. And anybody who has spent any time with toddlers knows that toddlers don't exactly hide their emotions well. You know how they're feeling. She wasn't scared. She was not scared of Steve. Not only that, but you heard from Officer Pocia that he actually said something incredible. He said that when Nevi and Stevie were taken away from their daddy, that they had separation anxiety, that they cried for him and they wanted to be back with him. Is that someone, a child who's afraid of their daddy behaves like that? Absolutely not. So the state wants you to make this gigantic leap that, I guess they're just trying to explain this giant hole in their case, which is what they're doing. So they want you to just ignore that there's this giant hole and they say, it's because she's scared. She was scared. There's no proof of that. And you can't make that leap without proof. Let me start again. There were first responders to the scene, as you know, and many of them had their hands on Omaree, who, by the way, was not wearing underwear. He was wearing pajamas. And all of them had their hands on him. You saw that in the lapel. They had their hands on him. They were feeling his neck, feeling his chest, and they said he was warm to the touch. And you heard from Toby Baca, one of the first people there, first responders there, and he said he was warm. And he also said if he was warm, then he could not have been down more than 20 or 30 minutes. He could not have been unresponsive for more than 20 or 30 minutes. So the state is trying to get you to believe that it was 3 to 4 hours that Omaree was down. That does not comport with his body temperature, that he was still alive. Look at that bag of ice. Still got solid ice in it. And you heard Steve tell the police what happened. Shower, CPR, at least his attempts at it. Certainly we can't hold him to the standard of medical personnel. His attempts at CPR, oxygen, ice. The ice was solid. So we heard Toby Baca, who said it couldn't have been more than 30 minutes. And then we heard from Dr. Ukpo. He's the pathologist, and he said, and his words were, that there would be a spontaneous drop, and that children are very different than adults, and that they could be sort of walking around with this condition, and there would be no outward signs that anything is wrong other than, whining, complaining, anxiety, as the state indicated, that's correct, but no outward signs that, and these were his words, immediate medical attention was needed. No outward signs of that. Instead, what Dr. Ukpo said was that there was this sort of small, slow bleed from capillaries, so small that on autopsy they couldn't even find the source. And capillaries are tiny. And that's why he said it had to have been hours that the bleed was happening, but not hours that he was down. We know that was 20 to 30 minutes. No symptoms with internal bleeding. No symptoms to show that immediate medical attention was needed. You heard from Mr. Casaus in his statement to police that he came out when he saw him like that, and he immediately did what he thought he should do. And of course, everyone's going to handle a stressful situation differently. We can't all be held to this medical standard. He did what he'd seen on TV or whatever. Maybe it wasn't perfect, but what he did was what he thought he should do. And let's not forget that you heard from Cynthia's mouth and from Steve's mouth that he kept saying, call 911, call an ambulance. What else could you do, really? I'm not going to go through the jury instructions, but I want you to look on that count 2 for the medical neglect. What witness, what evidence did the state bring you that had Steve Casaus acted quicker, differently, or done something else than he did that would have saved Omaree's life? Did you hear one witness get up there and say, if he had done this, he wouldn't have died? No. And I think that's a really, really important question that the state needed to answer for you. What could Steve have done differently? Or what sort of act did he do that caused Omaree's death for the medical neglect? Did you hear one witness say anything about that? No. Remember, so the state said that the defense put out some red herrings here. Again, it's not our job to prove the case. It's the state's job. So I'm going to talk about some of the distractions. They're distractions, but they are not proof beyond a reasonable doubt. So start with the towel. It was Pat Wright, Officer Pat Wright, who said, well, she thought it was suspicious that Mr. Casaus was drying his hands on the towel. Where's that towel? It was not put into evidence. There was absolutely no forensic work done on that towel. And in fact, you heard from the major crime scene investigator that he didn't even know about the towel. No one told him, hey, I saw, we have this child who's critically injured, and I saw one of the adults in the home drying his hand. We better collect that towel. No. It's a distraction. Then you hear about this alleged drug paraphernalia. Same thing. Major crime scene, investigator talked about how, he thinks it was drugs. He thinks it was drug paraphernalia, but he did not know that there was a diabetic in the home. And even more importantly, did you hear from a chemist that they actually tested it and found drugs on it? No. And did you hear that the major crime scene investigator or any law enforcement officer bothered to collect that stuff and put it in a bag, like I talked about, tag it, put it in a bag to save in case he needed it in the future? No, they didn't do that either. It's a distraction. If it was so important, this towel and this drug paraphernalia, why wouldn't they have collected it? The cigarettes, they showed you pictures of cigarettes that were in an ashtray. I'm not quite sure what that proves. Someone smoked in the house? They didn't test that for DNA. And then the state has made a big deal about the number of phones that were in the house. But you heard no one tested the landline to see if that worked. And I don't think the state can argue that in a stressful situation, that even in a non-stressful situation, that sometimes it's hard to find your cell phone. You saw all the stuff they had in their house, stuffed animals, Christmas decorations. But even more importantly, the state had the phones. They had them in their hand. They took them away. Where are those phones? Where is the forensic evidence off that phone, those phones? The state didn't bring that to you. So we have no idea if anything of value is on those phones. It's another distraction. There is no evidence as to who called who or when. There is no evidence at all. What's text messages? Nothing, because the state didn't bother to do it. And now let's talk about Steve Casaus' statement to Detectives Quillman in English. The state is now making these what they call contradictions a big deal now at Steve Casaus' trial. But at the time that he was in their custody, in the interview room, those contradictions weren't a very big deal. They knew him. They knew that the contradictions were there. They knew that Steve was changing his story. What did they do? And the state is absolutely right. We are going to make a big deal out of that, because it is a big deal. Because despite knowing the contradictions, knowing about the supposed towel and the drug use and all this other stuff, including these hands that are supposedly swollen, I'll talk about in a second, let him go. Detective Quillman admitted he escorted him out the building. Why would they do that if these contradictions were such a big deal? They didn't change. It's not like Steve gave one story then, let him go, and then he gave another story later, and then you're hearing that. It was all at one time, and they let him go. Yeah, I am going to make a big deal about that. So these swollen hands, it's correct. Detective English asked about him, and he was honest. I use heroin. I'm not feeling good, coming down from it, and the heroin makes my hands puffy. Again, if they thought that this was related, that his puffy hands showed that he somehow struck Omaree, why wouldn't they do something about it? Forget about, the fact that they let him go. Why wouldn't they test his hand for DNA? You heard through the witnesses that DNA, and you know this, DNA is really sensitive. And that Detective Quillman admitted it would have taken seconds to just Q-tip across the hand. They had him there. They got a warrant to take his clothes. You saw him in that, what they call a bunny suit. They got the warrant for his clothes. They say his hands are puffy, but they don't test him. And they let him go. Oh, and when I asked Dr. Quillman why he didn't do it, he said it's not his job. Well, whose job was it? Because no one did it. You heard that typically what OMI does, the medical investigator, when they're going to collect someone who's died, they put, and they're concerned that it might be homicide, they put those bags over the hands. And as you know, and as you heard through the testimony, the bags preserve evidence. Because there's hands, anything you touch is going to have, you're going to leave a trace of yourself or trace of other people on your hands. And they actually went through the effort, OMI did, to bag Omaree's hands, but no one did anything with it. Clipped his fingernails, tested what was under his fingernails. They didn't do that either. You heard from Dr. Upham and Kim Brown, the nurse at UNM, that this looked like a bite mark. And the inference the state was trying to make you get to, is that Steve did it. It's a distraction, really. And if you think about it, and if you think about what Dr. Akpo, who is a forensic pathologist, said on the stand, someone who's trained to find out what happened, what did he say? He said that forensic odontologist, which, by the way, Dr. Upham didn't know what that was, and actually scoffed at defense for even saying forensic odontologist, said, yeah, it was suggestive of a human bite mark, suggestive, but not conclusive, and that it was of a small human, a child. So why did the state even bring that up? Because they wanted to distract you. Dr. Upham and Kim Brown talked about these hyperpigmentation marks above Omaree's nipples. And both of them said those were bruises, absolutely. And this child was more bruised than any child I've ever seen. But then you heard from Dr. Akpo, who said those were not bruises. Hyperpigmentation, a distraction brought by the state. Another distraction was this sort of thing that they were inferring that Omaree was being starved. He was malnourished. Where's the proof of that? Actually, you got the opposite from Dr. Akpo, which was that he was in the 50th percentile on the curve. Anyone with kids knows about that curve. He was in the 50th percentile, and in fact, when they drew his fluids, they saw that he was hydrated and adequately fed. His nutrition was fine. It was a distraction that he was malnourished. This is the last chance that we get to speak with you. The state gets one more opportunity. And so I'm going to wrap it up here. I want to thank you. I want to thank you, Mr. Casaus and Mr. Clark. Truly thank you for sitting through this very difficult case. And taking the facts and taking this case as seriously as it needs to be taken. Remember, we didn't have to prove anything to you. We didn't have to put on a case. We don't need to prove that Cynthia did it. The defense does not need to prove that Cynthia did it. It's the state had to prove everything. And remember, we talked about in voir dire this reasonable doubt. Remember that. Any of the doubts that are going through your mind right now, any of them, are enough to acquit Mr. Casaus. Any one of them. You don't need a bunch. Now, you're going to need to be brave. That's an understatement. You're going to need to go back there, and you're going to need to have some courage to do the right thing here.
Objection, Your Honor.
I'll move on, Your Honor. You're going to need it. You'll need to be brave. Remember, when you go back there, that Detectives English and Quillman had all the same evidence that you have now. The only thing that's different is this Nevy statement, which isn't really reliable. It's far from it, actually. You have a little girl who has been through it. But what Detectives English and Quillman had at the time that they decided to let Mr. Casaus go, despite the fact that Omaree was dead, is the same evidence that you have now. There's nothing new. Now it's your turn. It's your turn. Let him go. Find him not guilty. Thank you.
We're going to just go through and finish up and then rebuttal?
Yes, Your Honor.
event started right where I left off, talking about the red herrings, the things that were meant to throw you off. And that's what they led with. They led with the things that are where they're trying to mislead you. That he was released the same day. And they said at the very end that, oh, it's because you have the exact same stuff. But you don't have the exact same things. They didn't have the autopsy, the medical reports. They hadn't had a chance to review all of the lapel cameras. They didn't have any of the statements from Nivea. They didn't have any of her drawings. They didn't have a whole host of things. They also didn't have time to contemplate what had just been said by both Cynthia and Stephen. So they took the person that admitted what happened in the room, and the person that lied about what happened in the room, they let go temporarily. But at some point, they did feel like they had enough, and so he was charged. And that's why he's here. And just because Cynthia is guilty doesn't mean that Stephen's not. And so when you look at the evidence, you see that he is also guilty of everything that happened. And while defense was reading to you some of the things as it relates to count 1 from Nivea's statement, they left a lot out. Because when asked, just with an open-ended question, what happened to Omaree? She says, he got hurt. When asked, how did he get hurt? She says, he got hit. Who hit him? She says, my dad and my mom. When asked if she remembers that day, she says, no. Do you remember how they hurt them? They slapped him and punched him and kicked him. Did you see this happen? Yes. She goes on to say she came out of her room because she heard screaming. And she saw what happened. And when asked who was screaming, she said Omaree. And when asked what he was saying help. Later on, at the end of that interview, she was asked, and what happened that day when Omaree was hurt? She said he didn't wake up. And when asked who hurt him that day, she said both of them. And when I asked to clarify what was that, she said both of them. And I said, both of them? And she said, hurt Omaree. And when asked, both of them hurt Omaree? She nodded yes. There's also a lot of emphasis on that one picture, that last picture, and talking about when it was done and how it was done. And it's implied that that's the only one where you see the defendant in it. It's not. You have all the drawings. Look at them. At least 2 of the other ones have the defendant. And he's not doing nice things. That's also implied as the first time she starts saying anything bad about her dad. But again, that's not the first time. She made it in the statements to the defense attorney when she had the opportunity to interview her. She made it to the interviewer at the safe house. And she made it, and she said it to Sylvia. She said it repeatedly. Months. She's been describing this. Dr. Penland would imply that this was some sort of implanted or made up story. And then once again, this goes back to one of the other red herrings. The idea of Dr. Penland. They're trying to have you believe the testimony of this person who couldn't name a published study, but when confronted with published studies that didn't get the same results, she said, oh yes, that happened. She could only say, oh, there's lots out there, but when asked for specifics, she was never able to provide you any published specific study about what happened. And defense just makes it sound like, well, psychologists are unethical. They make problems all the time. And that's not true. There's a reason why there's the Human Subjects Committee, is because they want to make sure that the tests with humans are done in an ethical manner, and that these tests were not. And defense also, in the same context, talks about how the argument about safety doesn't make sense. But it does. Think back to what the testimony was from Sylvia. When she was up here talking about what was going on, she talked about how afraid she was. She talked about that fear of them coming back, that she was having nightmares, that the defendant was coming to get her. And it wasn't until she felt safe that she disclosed any of the abuse. And you see the drawings. There were some additional comments about things like the drug paraphernalia. And there's no reason for the defense attorney to try to cast doubt on that there was drug paraphernalia found in the house. She's essentially asking you to call her own client a liar, because he admitted to using drugs that day. He admits in his statement that he put the paraphernalia in the trash. This is just confirmed by the photo. There's no reason for it to be false. It comports with what the defendant said he had done that day, that he woke up, went to the bathroom, got well by using heroin, and then Omaree was hurt. Some of the distractions the defense talked about that the state was trying to do was the ideas of like the bite mark and the bruises and the other things. But look at those photos. Kim Brown wasn't referring to just the hyperpigmentation. There are numerous bruises on this child's body. In his abdomen, his back, his legs, his arms, his face, his head. His whole body was covered in bruises. That's what Kim Brown was talking about. That it was the most injuries she'd ever seen in her experience at the pediatric emergency room. And Dr. Upham says that they see child abuse pretty much daily in that emergency room. In count one, it's the physical abuse. The defendant participated in the acts that killed Omaree. And a lot of that information does come from Nivy. A lot of it comes from other sources. You heard the statements and the letters from Cynthia. You have the statements and drawings by Nivy. And you also has his own statements to the police about why he'd want to intimidate Nivy. If he hadn't done anything wrong, why is he telling her not to tell so that he is safe? He's intimidating Nivy because what she's saying is correct. Listen to the end of that statement, and you hear that he's aware that she was there and present. And he's there intimidating her at the very end. It's the very end of that statement. And he's doing it because he knows that she witnessed it. Listen to those last few minutes. It talks about both of the intimidation counts. We talked about the bruises. The other charge was the burns on the chest, those thermal injuries.
Beyond scope.
Let's go on there. Come forward.
And you have that count to consider. You have the count for the bruising, as discussed by Kim Brown, Dr. Upham, and you can look in the photos, and the statements from Dr. Ukbo. Defense also mentioned, as part of, when they were talking about the statements that Nivy made, one of the statements that Nivy made was the bleeding that she saw on Omaree. And that goes to that tampering of evidence charge that he washed Omaree clean to avoid prosecution. The last count I would like to talk about are the different variations of count 2, the medical neglect charges. Defense was trying to imply that the state had to prove that this child would have been saved if this intervention happened at this point. That's not in the instructions. When you read the instructions, that's not what it's going to say. The instructions, in some variation, are going to be that Stephen Casaus medically neglected Omaree Varela. That Stephen Casaus caused Omaree Varela to be placed in a situation that endangered the life or health of Omaree Varela. That he did this intentionally. That his conduct resulted in the death of Omaree Varela. And that Omaree Varela was under the age of 12. That's the first thing you're going to consider. The second one you must find, and this is going to, that it was recklessly caused or recklessly permitted, when he did this with reckless disregard, that you must find Stephen Casaus caused or permitted a substantial and unjustifiable risk of serious harm to the safety or health of Omaree Varela. A substantial and unjustifiable risk is one that any law-abiding person would recognize under similar circumstances, and that would cause any law-abiding person to behave differently than Stephen Casaus out of concern for the safety or health of Omaree Varela. Anyone else would have acted differently. Seeing this child in that situation, they would have acted differently. They would have gotten help. They would have called 911 sooner. They would have picked him up and driven him to the hospital, which was about 10 minutes away from San Mateo and Comanche. they would have done more than 5 seconds worth of chest compressions. The defendant didn't do it because he was not wanting to be prosecuted. He was not wanting to be caught. He was not wanting to take responsibility for what he did. And you see that in his statements. Again, those last few minutes on his recording, when he's asked why he doesn't call 911, he says because he didn't know where the phones were. Defense says, like, well, people lose their phones all the time. Defendant had it when Officer Edison is in the home. He had it the whole time. When asked by Detective Quillman, why didn't you take the phone or call 911? He responds, I was just paranoid. I was scared. Yes, the baby should have come first, and I should have said that and spoke up and said something. He later continues to admit that I should have spoke up sooner, called 911 sooner. He admits, so I guess you could say I should have been more of a man and stepped up when I should have done that right away then instead of waiting until now. Defendant admits he didn't do what was right. He admits that these actions were wrong. And these actions, there's a lot of conflict regarding that first count. And you should still convict him for being part of the abuse based on the testimony from Nivi. But regardless what you think about that first count, count 2 is strong, and regardless of the actions, the defendant didn't do anything to try to save his life. Regardless who you think did it, Stephen Casaus failed Omaree by refusing to get aid. He failed him as a parent. He failed him as a human, choosing to watch him suffer. He watched him go through those stages of the anxiety, the altered status, the unconsciousness, and then death. And it's misleading for the defense to try to argue that, oh, his body was still warm, so he must have only been down for about 30 minutes. That's not what it means. It means you haven't been dead for that amount of time, or your heart is still pumping within that time frame. You can be going down this path towards death, and your heart is still beating. Your body doesn't start to get cold until the circulation becomes too poor or the heart starts beating altogether. That just means he was at the very end. His actions were intentional, they were reckless, and he purposefully lied about what happened multiple times. He lied about the phones, about the times of when it happened, lied about what he knew, and the most damning thing of all is what's pointed out by Detective Quillman, is that even after they called 911, he continued to lie. If ever there was a point for him to step up and say what happened, to possibly get that life-saving help from the paramedics or the doctors, it's when they're there. But instead he continues to mislead them and lie about the fall from the horse. That was intentional. That is where Omaree's there fighting for his life, and he's refusing to even give the slightest bit of aid. Just kind of tipping off the paramedics or the doctors in the right direction. No, he sends them down the wrong path. And he knew it. He knew Omaree was in trouble. He saw the aid that Omaree was getting. Knew he was struggling to breathe in the statements to the police. And he continued that lie. He chose that lie to protect himself and Cynthia. He says he just didn't want to get anyone in trouble, including himself. He hoped it wasn't really happening. But it was, and he chose not to do anything. And when given the opportunity, he intentionally misled the police and the paramedics. They say actions speak louder than words, and it's those acts by the defendant, misleading the paramedics. When given opportunities to try to call, he left Omaree there to bleed on the floor and in the bedroom. Those are his actions, and those are the actions that speak to his guilt. And so for those reasons, you should find the defendant guilty of counts 2 in all forms. You should also find the defendant guilty of all the other charges based on the statements that you've heard from Nivi and the officers and everybody else. Thank you.
Now I'm going to ask you to retire folks to begin your deliberation. You will, as we discussed earlier, be provided copies of the jury instructions taken with you, certainly. And prior to beginning your deliberations, I'm going to ask you to select one of you to act as the foreperson, and that person is going to preside over the deliberations and speak for the jury here in court. Now, forms of the verdict have been prepared for your use, and you'll take these in the jury room with you as well. And when you've reached a unanimous agreement as to your verdict, the foreperson is the one that's going to sign the forms which express the verdict of the jury. You will then return those verdict forms, instructions, exhibits to the courtroom. And so at this time, there's 3 alternates who will not going into deliberate. Randy Smith, Samuel Shaw, Benjamin Wood. We're going to have you go to my office. Ms. Pat will take you down there. I'll spend just a little bit of time to talk to you. The rest of you are going to go into the jury room and begin your deliberation. So once you get in there and get settled, I think we're going to provide some lunch. We'll then get all the stuff in there with you. Okay? All right. All right. Let's rise. Please be seated, folks. All right, what we'll do at this point, I think we're going to, since they're actually, it's 12:20, start the deliberations, so we'll probably end up taking them to lunch or bringing it in so we can begin the deliberations. I need, probably beginning about 1:30, that you are within 10-minute earshot of the courthouse in case there's a question. Certainly, as complicated as cases there may well be, so please be close so that we can do that. We'll go up until 5. If at 5 o'clock they haven't, maybe about 10 till, we'll check in and see how they're doing. If there is obviously still a need for further deliberation, then we won't call everybody back to dismiss them. We'll dismiss them with the admonitions to keep themselves sequestered and not talk about it, and then back here tomorrow morning at 8 o'clock, so we can begin deliberations back here. So beginning at that time tomorrow, I want you within 10-minute earshot as well. Make sure Ms. Pat has your cell phone number so we can get in touch with you at that time. So we can have Mr. Casaus here by that time as well. All right.
Your Honor, as far as the alternates go, is your practice to allow the alternates to speak with counsel?
Oh, of course, and I will encourage them to do so. I just, I have a little certificate and things that I'll provide for them before I let them go, and I'll encourage them to talk if you want to be out there, either side. The other practice is because of the complexity of this case, I'm wondering if we shouldn't just keep them under wraps. But I think I'll probably let them go, and we'll be on the 4th floor,
okay.
outside the atrium area of my chambers, okay?
Yes, sir.
All right, so either side certainly can go out and talk to them if you wish to do so. I'll encourage them to do it. They're certainly not required to do so. If they would like to, they certainly can do so if they want, okay? Otherwise, they might want to go home. All right. Is there anything we need to address before we get all of this to the jury? We need to make sure that all the evidence that was used and admitted in this case is brought back here so we can gather it and take it in there when it's all done. The other, I think we'll probably supply for them a computer with a DVD drive so that they can view at their leisure any of those that they wish. Unless the state has one, is that what would you have available without anything else on it?
I'll have to check, because the concern is that some of those laptops also have access to the internet.
Yeah.
And we're trying to.
Yeah, ours won't, so we'll just use the one that we've got, and we'll get it to them shortly after lunch. Okay. So I'll provide for them 6 copies of the jury instructions. We'll have 12 copies of the statements of Anivia that will be provided for them as well for purposes of their review if they wish. All right. Is there anything else, counsel?
Please, sir.
From the state?
Did you want us back here to dismiss the jurors, or will you do
No,
that?
I don't want you to do that. I won't, there won't be much that will be done except my admonition is to keep themselves sequestered, and we won't have a long conversation. It'll be by me, and we'll dismiss them right about 5, and then have them back here tomorrow morning at 8. And so at that time, I'd like you to be available again within 10 minutes or so. Unless there's any objection to the court doing it that way. I certainly can bring you back here, and we can do it that way if you like.
No, Judge,
No,
that's
sir.
fine.
Oh, all right. All right, thank you, and we'll be in recess. Make sure to check before you leave that we have all the evidence here.